I filed in 1982 a federal action at the Federal District Court in Orlando, where the court has jurisdiction over me. The case number was 82-200 CIV R. R stands for the first letter of the judge's name, Reed. 82-200 CIV R. The case was assigned to Judge John A. Reed, Jr. In the meantime, I went and engaged the services of a lawyer from India, from Pali, by the name Cyriac D. Kappil, Kappil. He was a prominent lawyer, young, vibrant lawyer. He was well respected by the society. He was well known in the field. I brought him to Orlando to present my case to the court. The defendants, AT&T and Michigan Bell, engaged a law firm called Carlton Field Emanuel Cutler and Smith, is a long name, in Tampa. They came up with a motion to dismiss. Motion means a request to the court. That's what you hear, motion. Motion to dismiss the case, interposing release as a defense. They are claiming Mr. David signed a release, so although we fired him illegally, he signed a release, so we should be let off the hook. That's the defendant's argument. Judge John Reed denied the defendant's motion. The order of the court read, which is dated Orlando, September 8. Here is a copy of the order of the judge. Filing date 27 September 1982. Disposition denied. The defendant's motion to dismiss was denied by the court. The court is of the opinion that the amended complaint, when tested against the standards of pleading normally applied in federal courts, it is adequate to withstand a motion to dismiss for failure to state a claim upon which relief may be granted. The motion to dismiss is denied without prejudice to the right of the defendant to assert any affirmative defenses which may be available. The defendant shall have 20 days from the date of this order. It says it is further ordered that the defendants raise a defense based upon a release, and if the validity of the release is contested by the plaintiff by a reply, the court, pursuant to Rule 42B, Federal Rules of Civil Procedure, will conduct an evidentiary hearing limited to the validity of the release and will make a preliminary determination of that issue. See Alexander versus Gardner Denver Company, 415 U.S. 36, footnote 15, 1974. It is further ordered that until further order of this court, discovery shall be limited to the validity of the release. This is important, folks, because what the judge is saying, the defendant's motion to dismiss based on the release that they interposed is denied because, according to the U.S. Supreme Court, its ruling in Alexander versus Gardner Denver, footnote 15, the Supreme Court said, an employer can obtain a release from an employee provided it was given by the employee freely, voluntarily, and knowingly. There are three-pronged test laid down by the Supreme Court. The defendants, AT&T and Michigan Bell, totally disappointed. They were contriving plans to beat me in the courts. One of the first tactics they deployed was to approach the Chicago Cook County to make my lawyer a federal judge so that he will get off the way. I was sitting in Chicago in Mr. Kappil's office. The phone rang. The Cook County said, I want to speak to Mr. Kappil. I picked up the phone. Mr. Kappil said, I am not interested in a judicial position. Then the defendants attempted to give him cases so that to dissuade him from continuing my case or to influencing. He said, Mr. David, I am not interested in what they offered me. Then they tried to threaten him, saying that if you continue on this case, we will make this very expensive. You will not be able to continue as counsel for the plaintiff. Mr. Kapil called me promptly and told me, Mr. David, I'm getting a lot of threats. What do you want me to do? You can't afford to pay me. I have to fly from Chicago to Orlando, and then the flight expenses, the hotel expenses, my attorney fees, which will be very, very high if they are going to do what they promised or threatened. So finally, myself and Kapil agreed for him to recuse from my case. I signed a release, and I took over the case pro se. Folks, these mighty corporations, I call them mafia corporations, they have different things, different tactics. First tactics was to dissuade my counsel to get off the case. Mr. Kapil was eventually murdered. Mr. Kapil was eventually murdered. I don't know whether these mafia corporations have any direct or indirect involvement. According to the press report, he was murdered by two Indians fighting, and one of them took a gun and shot him and killed him on the spot. I did not know at the time, because I was busy with a lot of things, I didn't have a chance to listen. I did not know my counsel's untimely death or murder. Folks, after I took over the case from Mr. Kapil, pro se, defendants engineered another plan. This is where I want you to listen to, folks. This is the second part of the gimmick going on in the United States courts. The defendant, besides having the law firm of Carlton Field, Emanuel, Cutler and Smith, whatever the name, Tampa, they brought a new person. Who is the new person? A woman who used to work for this judge, and who is also a close friend of this judge. Her name is Anne C. Conway. She was then a lawyer. They hired her solely to influence peddle with this judge, to let them off the hook. Folks, there is no problem a party hiring a lawyer. Doesn't matter what lawyer, they hired a lawyer. I did not know at the time this woman used to work for this judge as his law clerk for 3 years in Orlando. I also did not know, folks, this woman used to go to his home, and he used to go to her home, and they were meeting in private. Folks, these are very prejudicial information. The judge and this woman, Anne C. Conway, intentionally refused to disclose this to me for 2 years, 2 long years. My case is in the court, pending there, no proceedings. Every time I go to the court, the judge will say, Mr. David, come into my private room. Nothing in the open court. Why? Because they want to cover up this connection with this woman, because public knows, practicing lawyers in that town know that this woman used to work for the judge. So the judge doesn't want the proceedings in the open court, nor this woman. This woman is now made the chief federal judge in Orlando, Florida. Subsequently, you have to understand the whole corruption teams working together in cahoot with each other. Folks, I went to the court every time the judge scheduled what is called a status conference. No discoveries. You mind this, lawyers, judges, students, the intelligentsia of the world community. I ask you to listen to me. In the federal court, it is like you going for a war. You can't go to a war when the other party has atom bomb and the little guy doesn't even have a gun. You understand? The purpose of the discovery is designed to enable parties to oppose each other, to expose them, to contradict them, to prove facts, get the facts of the case. In the American system of jurisprudence, folks, you have a right to demand a jury trial. What is a jury trial means? Maybe one day the court will call 500 people who are eligible to vote to attend a meeting, and the lawyers and the judge will challenge each person, interview them, talk to them, and they finally decide 6 people plus 3 alternate in a civil case and 9 plus 3 in a criminal case. These jurors, they make factual findings. They have the sole authority to make factual findings after hearing witnesses and parties. And the judge only answers questions of law. And in the Constitution it is provided you have an inviolate constitutional right to have a jury trial if the amount in controversy exceeds $20. It means you don't have to listen to the capricious and arbitrary determination of a judge. You can demand a jury trial. Folks, I demanded a jury trial. The judge did not make any ruling on that issue. Okay, on the docket sheet, you will see first page, jury trial demanded. The tactics of this Mafia Corporation was to bury me with the motion practice. We had 39 full pages of motion dockets entered in the system. 39 pages. They filed tons of papers, bury you with the motion papers. Then you have to respond. First you have to file with the magistrate for discovery. Magistrate will deny the motion, claiming you have no right to jury trial. You have no right to discovery. He never ruled on the jury trial demand, neither the magistrate nor the judge. They always denied you discovery. The blood of as a legal issue is the discovery. That's the means by which you penetrate into the arguments of the other party. Okay? So I was denied during the last 33 years any discovery at all by the various kangaroo courts. I'm going to go into detail what is going on in the United States. Folks, it's a shame. It's a shame for everybody. The lawyers, the judges, all the corrupt gang, the insiders who are fixing these cases. Folks, Judge Reed, other than holding occasional status conferences, he was not conducting a trial to determine whether the release that I signed is valid or not. I claimed that release was signed under duress. It is legally voidable, unenforceable. That issue, the judge said he will conduct an evidentiary hearing as per his order, which I read out to you early. But he won't conduct it. Why? Because the judge knew they have nothing to prove. They fired me in the presence of my wife. I didn't sign the release freely, voluntarily, and knowingly, as stipulated by the U.S. Supreme Court in Alexander versus Denver Gardner. So these two mafia corporations and this crooked judge knew that. So he doesn't want to conduct a trial. 2 years went by. 2 years. No trial, no hearing, no evidentiary hearing, no discovery. Folks, I began to become suspicious of what is going on. I sent this judge a 20 questionnaire asking him to disclose certain information. Folks, I'm not a lawyer. I sent this questionnaire because I am acting pro se as my own lawyer. Folks, this judge, who is a sitting federal judge then, he called me on the phone to Yonkers, New York, where I was then living. His new law clerk called me and said, Mr. David, Judge John Reed wants to speak to you. I was surprised. Judge John Reed wants to speak to me, a federal judge, to a pro se litigant, a non-attorney. Anyhow, I picked up the phone, I talked to him, said, Judge John Reed says, Mr. David, this is Judge John Reed. I'm not going to answer your questionnaire in writing, but I will give you answers over the phone. The federal judge is saying he is going to give me certain answers to my questionnaire, not in writing, but over the phone. I said, Judge, I would like to have the discussions tape recorded. If I don't get permission, then I will be committing another federal crime. So the judge, after consulting all the people on the phone, AT&T lawyers, Michigan Bell lawyers, the law firm, all the people listening to, said, fine, Mr. David. The judge admitted, folks, A, he is a shareholder of AT&T, then at the time when the litigation is going on. 2, he had worked for Southern Bell Telephone Company, which was then a subsidiary of AT&T, as its lawyer for so many years in their land deals. 2, 3, Annie Conway and Judge Reed, they are close family friends. 4, he had been to her home in private when the litigation was going on, and Miss Conway had seen to him to his house, and they met in private in Atlanta and other places. Folks, what kind of justice you can expect to have from a judge whose close friend is representing the defendant? Do you think you see what I'm talking about, folks? And this judge and this woman had certain duties, canons of ethics they are covered by. They should have disclosed this not at the end of the game, but at the beginning of the game, at the beginning of the litigation, which they didn't. They kept this as a closely guarded secret. Folks, after the telephone conversation with Judge John Reed, I notified the FBI Orlando, and I also sent a letter to the Chief Justice of the U.S. Supreme Court. His name is Warren Burger. Warren Burger was a terror because lawyers don't like him because he's doing his job. Okay? As a Chief Justice of the United States Supreme Court, Warren Burger was, I think he's died now. He was doing his job, so lawyers don't like, the crooks don't like him. After reading my complaint, it appears to me, Judge Reed resigned from the bench. But before resigning from the bench, he issued an order of recusal. You can see a copy of the recusal. So Judge Reed recused from the case and resigned from the bench. You understand? And he did one more favor to the defendants. Folks, in America, if you have a case in a particular court in a particular district, and if one of the judges either become ill, died, or sick, then the case should be reassigned to another judge in the same court. AT&T, these two mafia corporations, they don't want that. They want to drag this from this forum, Orlando, to Tampa, which is approximately 1,500 miles. I mean, sorry, not 1,550 miles away to another district that's called Tampa. I'm getting an order from the new judge. Mr. David, appear before me in Tampa. Last 25, more than 30 years, I was living in New York. And at the time when the transfer from Orlando to Tampa took place, I was living in New York. I made a motion to this judge, the new judge. His name is Terrell William Hodges, Hodges. You can Google everybody and see on the on the Google. You can read everything about everybody. I get an order. I go to the Tampa court and I told the judge, Judge, you have no jurisdiction over me. I live in New York now. Transfer the case to New York. No, Mr. David, I am not going to transfer this. Okay, denied every motion that I filed. He wants me to come from New York to Tampa to take part in the kangaroo court proceedings. That was the purpose of transferring the case from Orlando to Tampa. Folks, this judge also issued an order saying that I am going to conduct these proceedings in accordance with the rulings and parameters as previously ruled by Judge John Reed. Did he do that? No, folks, cowards die so many times. These cowards die as cowards. He didn't conduct a trial. He didn't conduct an evidentiary hearing that was decided in 1982. The deal under the table is this new judge will put off the case until they hatch a case law. They hatch a case law from another jurisdiction and will ask the judge to apply that case law to my case. See the tricks? AT&T and Michigan Bell fired another white person. His name is McDonald. He was a division manager working in New Jersey. Under the scheme, under the, these all well-planned, orchestrated plan, this company, this mafia company, gave him $11,000 or $12,000, and Mr. McDonald go to the state court. The state court in Michigan says, Mr. McDonald, you must first refund the money before you can sue the company. So what they do is they keep my case filed in 82 in a state of suspended animation and get this decision from Michigan, obtained the same day. This Court of Appellate Court paid the decision, bring it to Tampa. Make a motion to dismiss my case, saying that Mr. McDonald is required under the Michigan law to refund the money, so that Mr. David also should do likewise, otherwise you should have the case dismissed. Folks, there are federal procedures in every court. Every judge is required to follow those rules strictly. Rule 1 of the Federal Rules of Civil Procedure states the judge has to conduct cases expeditiously to the least cost to the litigant. Expeditiously. There are a lot of latest rules which say the time frame within which a judge has to decide case. Not 33 years. Folks, such shame. 33 years, no trial, no bench trial, no jury trial, no discovery for me. I am a US citizen, United States citizen. This is what I am getting, the type of justice. Folks, whatever I said so far is only a beginning of this case. The drama has started. This is a thriller, those who want to watch. I am going to make it soon a movie. I am requesting all those listening me, if you can, help me to make this movie so that the civilized world can understand what is going on in the United States District Court. Folks, Mr. Terrell William Hodges wasted no time. There are rules which say once a party files a motion for summary judgment, the other party is to be given certain time limit within which to oppose the motion. These days, these rules are for fools, Mr. David. I am the chief judge here. I can do whatever I wanted. No, as soon as he gets this order, he prints an order. Okay? The judge has no facts, he has only pleadings. One party filed a complaint, the other party filed a motion to dismiss, which was denied by Judge Reed. This judge makes some findings of facts from his hat. He takes his hat, he makes findings of facts. And in his 5-page opinion, he says, Mr. David, you should refund the $50,000 given to you, failing which the case will be dismissed without prejudice. Mark the word without prejudice. Without prejudice is a legal expression, which means you can restart the case is not decided on the merits. That is what is a 5-page order. I have it here, you can see it, it's going to be shown. Folks, there's a scheme going on. It's not one player. There are so many players, so many paid agents working for these mafia corporations. Many may claim they are benevolent corporations, but when they fire an employee illegally in violation of the law, they still claim we are good company, good corporation. What the defendants did was, they might have definitely paid the money under the table to the clerk of the court or deputy clerk of the court, as the case may be, man or woman, I don't know. That person issues a judgment. The judge issues an order. The clerk of the court issues a judgment. The judgment, I am going to show you also for the viewers a copy of the judgment. The clerk says the case was dismissed on the merits. Folks, listen. The judge says dismiss the case without prejudice. The 5-page order, the lawyers, AT&T lawyers, these Carlton Field, Emanuel, Cutler and Smith, Annie Conway, and others, another lawyer, Peter Cinnabar. These are the lawyers representing AT&T. Peter Cinnabar was the lead counsel. He read the ruling of the court, 5-page order, which says dismiss the case without prejudice, and the clerk says case is dismissed on the merits. Folks, there is a reason why they want to change it that way. They know that I am going to appeal, so they can do something there in the United States Court of Appeal for the 11th Circuit in Atlanta. That's where the appeal from the Florida region goes to. The defendants, their learned counsel, 3 of them, they file jurisdictional statements. Jurisdictional statement, they have to tell the Court of Appeals, the court has jurisdiction to hear the matter. Folks, if a case that was dismissed without prejudice, it is not a final judgment on the merits. The United States Court of Appeal has no jurisdiction to hear the appeal. Understand? What this mafia corporation did was change that to suit their need. I have a copy here which I am going to display. You will see. They filed a jurisdictional statement pursuant to USC 1291. The court has jurisdiction. When the court has no jurisdiction from an interlocutory order, they are now attaching a copy of the fraudulently obtained order of the clerk of the court, which says the case was dismissed on the merits. On the merit means parties presented arguments, they brought witnesses, the judge heard all the arguments and everything. Then the case was decided. That is the meaning of the word on the merit. In this case, there was no hearing at all. I was given no opportunity whatsoever to submit my legal arguments. As soon as this mafia corporation obtains this Michigan case law, They move, and the next day the judge issues the order. No time for me to respond. No, there are procedural requirements. These rules are Federal Rules of Civil Procedure. Federal Rules of Civil Procedure. Okay? These are all rules of the court. Federal Rules of Civil Procedure. This is a constitutional right and liberties of citizens. Constitutional right. Okay? These are my constitutional rights. This is how they were being raped literally by these two mafia corporations. You understand, folks? In cahoot with crooked federal judges. These judges in 1981 made $50,000 a year salary. Okay? An ordinary laborer made more money than these federal judges. How do they supplement their income to maintain their status? They can't afford to live. $50,000 a year salary. So these corporations funded them under the table. The public don't understand, but you can guess. You can understand, people, if you have common sense, you can understand what is going on here. United States Federal Court. Okay? People think these are called the temples of people's faith and trust. Are they? People's faith and trust. No trust. In dog we trust. When you go to the court, you see, in God we trust. And I change that, I will say it's in dog we trust. Okay? Folks, this is not the end of the story. It is the beginning. In the United States Court of Appeal, where I filed my brief, I was given 5 minutes time to argue my case. They had already pre-picked the panel. The United States Court of Appeal at the time, to the best of my recollection, had 26 fine judges. 26, I don't say fine, 26 judges. Okay? These defendants know from their past experience which judge or judges are amenable to their tactics, where you can deal under the table. Folks, there were 3 judges impaneled on that day when I went for oral argument. Annie Conway was representing AT&T. Before I began my arguments, I told the judges, I have 6 legal issues to be presented to you. Give me more time than 5 minutes. One of the judges, I don't remember who, said, Mr. David, proceed on, we will consider. The light went on, the green light, I started speaking. Then the amber light came on the at the 4th minute. Then I was cut off at the 5th minute. The judge said, one of the judges said, I don't know who, we will read your pleading. Folks, waited a few months. I took a trip to Atlanta, flew back and forth, prepared pleadings, motions, arguments, briefs. And what I hear is a 2-word opinion, which reads, which I'm going to show to you, we affirm what this lower court judge, Terrell William Hodges, did. According to the U.S. Supreme Court, folks, another case, Supreme Court said in another case, you don't have to return the money to the employer before you can sue them. That's the holding of the U.S. Supreme Court. They say, forget it, Mr. David. Supreme Court will make many rulings. We don't follow a damn, because we can control the entire judicial system in this country. Folks, I want you to understand one more thing, which I forgot to tell you. In America, broadly speaking, there are 2 types of courts. One is the federal court, one is the state court. The state court hears matters relating to state issues, like local crime and other things, litigation between the parties. In the federal court examines questions relating to the federal violation. So, here the laws that were passed by the US Congress in 1964 was the Civil Rights Act of 1964 as amended, which says an employer cannot discriminate people on the basis of national origin, color, gender, blah, blah, blah. The ADA, which is the ADA, is age discrimination. Age discrimination, the Employment Act said an employer cannot discriminate you because of your age. Okay? Then the Congress passed another law, it's called ERISA, E-R-I-S-A. ERISA means Employees Retirement Income Security Act, which means when you work for an employer for a period of time, the employer has to give you benefits, pension. In this case, folks, these two mafia corporations had violated every law. They were found guilty by the US Department of Justice previously, and they had signed what is called a consent decree agreeing to the Department of Justice they will not discriminate persons based on these factors. That is exactly what they are doing. They are discriminating, and on the other hand, they are claiming, oh, we are good boys, we don't do that. Okay, folks, these three judges, his first judge is named Robert Vance, and the other one is Allgood. Third one is Larry Edmondson. You may see their pictures soon if I have it on the file on the system. Judge Vance, who affirmed he was murdered the same year, okay, by somebody. I understand the person who murdered him by sending him a bomb in the mail. He was a rich guy having a plane and everything. The last look at I had the Google, he was standing for execution in the federal or state penitentiary. So the first judge is gone, Robert Vance, gone. Second judge, Allgood, A-L-L-G-O-O-D, good, I think it's Larry or I don't know, first name, I have to look it up, Allgood. He committed suicide, took a gun and shot and killed him. Folks, the United States Court of Appeal judges. The third judge, Larry Edmondson, is a black guy. Read articles about him in the Google. I don't want to tell you. Google it. Larry Edmondson, Allgood, and Robert Vance. Folks, these judges affirmed without opinion. 2 words, we affirm. They don't give the rationale why they affirmed the arbitrary and capricious determination of Judge Hodges. Folks, people think in America, oh, you can go to the district court, Court of Appeal, and the US Supreme Court. That's the last court. That's theoretically. In practice, nobody goes to the US Supreme Court. You can file papers, you get a rubber stamp which says certiorari denied. This is a pre-printed form. The clerk of the court has to press the button, insert the name of the parties denied. Because the Supreme Court rules I have here, which I wanted to show to you, which says the granting a writ of certiorari is a discretion. It's a discretion with the court. You don't get a petition granted unless you are a big law firm, Jewish law firm with a lot of names, blah, 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 blah. So these are all well known in the field. Only when they present cases, there are a lot of things, people, once you know the legal system, you understand what is involved. The ordinary guy, it doesn't matter what race issues you are raising, they don't hear, they don't even see those papers. The 9 senior citizens, except Justice Roberts, the others are all senior citizens, they don't get the file. Who presents the file to the judges? Who presents what are the issues in the case? Each judge, Supreme Court justice, has 5 or more law clerks. So the next game is the defendants to approach the law clerks, promising them a judicial position either in the district court or court of appeal or in the US Supreme Court itself. These mafia corporations are the kingmakers. They install the President of the United States in office. They install the justices in the Supreme Court. They install judges and appellate court judges in the United States because they have the political and financial wherewithal. In addition, as you recently read in the papers or seen in the television, USA bugs everybody. 45 world leaders were bugged. They were listening to the conversation, including the Pope. So these mafia corporations, their job is, among other things, to listen to everybody they want to. You understand? And they have the special recording, they record. So no judge can have any privacy. They understand what is going on. So if a judge is going to do his job, they will use his weakness as a ransom. You understand, folks? These mafia corporations' tactics. I am not Mr. Snowden. I am not the WikiLeaks founder who exposed America. I am exposing these mafia corporations and their tactics. Folks, Supreme Court, as I said before, automatically sent a letter saying that petition for writ of certiorari denied. Certiorari denied. What do you do, folks? I have no other option. I can do nothing. I was working in a law firm in New York, and when I was going through the law journal, I happened to know at the time the difference between a dismissal on the merits and dismissal without prejudice. First time. I didn't know. I spoke to many lawyers. Do you know the difference? They don't know. Lawyers. I happened to read the law journal. I got the idea. So what happened in my case was the judge who issued the order directing the clerk to dismiss the case without prejudice, his order was altered by the clerk. It is not a simple clerical error. It was an intentional changing the order of the court by the clerk. I filed a motion under Rule 58 of the Federal Rules of Civil Procedure, 58 or 59 of the Federal Rules of Civil Procedure, asking the court to amend the judgment. After a few weeks, after a lot of arguments and objection by the defendant's counsel, the judge issued a 5-page order again. Judge Hodges. He stated in his order, the bottom line, he is directing the clerk to amend the judgment as a dismissal without prejudice, retrospective effect from the date of the original entry of judgment. Fine. Now, the Court of Appeal affirmed an interlocutory order which was altered by the clerk of the court. The US Supreme Court denied certiorari. Now 6 years later, the federal judge says, yeah, we made a mistake. I am directing the clerk to enter a judgment to dismiss the case without prejudice. Folks, when you get an amended order, what do? You have the right to refile the case again. Folks, I didn't do anything right away. I was, I believe, in my late 60s, and I am entitled to get a pension from these corporations when I reached the age of 65.6. So in 2006, I filed a new claim against these mafia corporations, AT&T and Michigan Bell. Fidelity Investment was the pension plan administrator, so I included them for the sake of asserting the jurisdiction of the court and bringing these parties in the picture. Folks, this mafia corporation now more afraid. Okay, we are in a major center of the country, New York, and they don't want their names in the television and newspapers. They deployed yet another tactics, folks.